All right. Good morning, everybody. I want to welcome you. We've got some people who have already messaged me saying that they were going to be late, or some people who actually are going to try to watch the video that we're recording right now later. So we have some of those this morning. It's just that way. I do want to take a moment and welcome you all, and thank you for attending our Chamber University. Before we get started, I wanted to let you know that this is going to be recorded for you to view later if you want or need to. I want to take a moment to thank Cedar Park Economic Development for being our presenting sponsor for our Chamber University series. Our speaker today will be Maggie Shahrestani, I think is how you say it, with the Shahrestani Law. Maggie went to Princeton, where she majored in history before going to the University of Texas, where she went to the LBJ School of Public Affairs to receive her master's in international and global studies and her doctorate from law at UT's Law School. She has been a mediator, policy advisor, associate general counsel before opening up her own law firm in April of last year. Today, Maggie will be talking about the legal risks in the age of COVID-19 and how having written company policies can save you time and grief. And with that, I welcome Maggie.
Good morning. Morning, everybody. Sorry, I have bars on my face and I have no way to fix it right now. My desk is not used to seeing me this early in the morning. I usually make my way upstairs a little bit later in the day, so apologies for that. But thank you so much for having me. I'm really happy to be here, and I will go ahead and share my screen so I can share this presentation with y'all. Let's see if I can get this to work. Okay. Can you all see that okay?
Looks good.
Okay, perfect. All right, so today I'm gonna try to leave time for questions at the end. Obviously, this topic, legal risks in the age of COVID, is extremely broad, right? COVID has changed a lot of things, like from supply chain to cybersecurity policies, to workplace safety protocols, that kind of thing. I'm going to be limiting my presentation today to workplace safety specifically, and I'll be focusing on non-healthcare employers. So if you're a healthcare employer, the standards are going to be a little bit different. So really, I'm going to be talking about the risks associated with employee exposure to COVID and how you can kind of address those and try and avoid those problems. A little bit about me. Let's see if I can, there we go. A little bit about me. I just got a wonderful introduction, but just wanted to share this. So I married my husband in 2019 on New Year's Eve. We have a dog named Rumi, who is a Great Dane Lab mix and a little bit of a nightmare. And that little blob down in the bottom left-hand corner is our daughter, Scarlett, who we are expecting in June. So that is the other big excitement lately. And as was mentioned, Alex and I together actually run Shahrestani Law, and we're a business transactional firm serving clients throughout Texas. And we work with startups, small to medium-sized businesses, and we really try to be kind of a go-to business attorney generally. Is there anything else I want to say there? No. Okay, so let's go ahead and just dive right in. So legal risks in the age of COVID. What we're going to be talking about today, legal issues arising from COVID in the workplace. What makes a solid COVID-19 policy? So having a response policy, a safety plan, how that protects you, what it should look like. And then if there's time at the end, I do want to talk briefly about vaccine policies and whether or not we should make, you as an employer should make vaccines mandatory. If we don't get to that, it might come up in the questions, but it's like a pretty timely issue. So hopefully there's a little bit of time at the end. So let's start with this. Why would your employees sue you? Everyone knows we're going through COVID, we're going through a difficult time. Why should I be worried about my employees suing me for a COVID-related issue? The first big thing is simply the cost of getting sick. So I think the most recent number I saw for a COVID hospitalization, average costs were $35,000 to $45,000. Now, depending on someone's health coverage, that's a lot to cover. Workers' compensation as well. If you're a participant in workers' comp, which I believe about 70% of Texas employers are, that doesn't completely eliminate your risk. So there are still ways to sue an employer who offers workers' comp. You simply have to make slightly different arguments, and it is a bit harder, but you could still end up being sued if you provide workers' comp to your workers. And the fact that workers' comp pays usually doesn't pay fully, right? It only pays out a small percentage of what people's actual healthcare costs are. That's what kind of makes it more likely that they would sue to recover the difference. Another reason would be termination. So if you fire an employee nowadays, obviously that always comes with huge legal risks, but COVID has sort of amplified that because employees can make the claim that, for example, you fired them for complaining about an unsafe work condition, or you fired them because they needed some kind of reasonable accommodation to one of your policies that you didn't provide, which violates some discrimination laws. So termination is another one. And then not feeling safe at work. So workers have the right to file complaints with OSHA, the Occupational Safety and Health Administration. And although that's not strictly speaking a lawsuit, it could result in fines for your company and investigation. And should that investigation happen and then someone later sue you, the report that's produced in that investigation can be used as evidence in their lawsuit. So it sort of lays the groundwork for more problems down the road. So we want to try to avoid that. And that's kind of where having good policies and procedures comes into play. So I'm going to talk a little bit about OSHA. If you're in the construction industry or manufacturing, you're probably very, very familiar with OSHA. They have all kinds of very specific standards for certain industries. If you're not in one of those kind of those heavier industries, you might not be as familiar, but actually OSHA applies to all employers. If you have even one employee, there are certain aspects of OSHA that apply to you, particularly this general duty to provide a safe workplace for your employees. The language specifically is that the workplace must be free from recognized hazards that are likely to cause death or serious physical harm to your employees. Now, there's a reason that doesn't come up very often, right? Like it's a pretty high threshold. There aren't a lot of situations in like an office environment or even like a retail or a restaurant environment where there's a hazard that's going to cause death or serious physical harm. But now that we're in the age of COVID, largely the consensus is that COVID does qualify because it can cause serious physical harm or death. And so you as an employer, or we all as employers, have a responsibility to make sure that we're keeping our employees safe. And if we don't take reasonable precautions, we could be liable under a claim based on OSHA. So as I mentioned, OSHA covers all employers with at least one employee. We definitely saw a rise in COVID-related, well, of course we saw a rise. We saw a lot of COVID-related fines in 2020 last year. So $3.9 million, there should be a dollar sign there, in COVID-related fines. And the way that OSHA would investigate a complaint by a worker is they would come out and they would interview people. They would look at your policies and procedures, and they would try to determine whether any illness that had happened, any COVID that had spread in your company was actually work-related, was actually caused by exposure at work. That's obviously very hard to do because any of us in the course of our day can be exposed to COVID. So I could be exposed to COVID at the grocery store, or I could be exposed to COVID at work, and it becomes sort of difficult to parse out which is the case. And you as the employer are only liable if the employee was exposed at work, right? So OSHA actually has discretion right now to determine whether or not the illness was work-related. I believe there is an appeals process, although I haven't come across it yet. But what they're going to do to the way they use that discretion, what they're going to do to try and figure out whether the illness was work-related is they're going to use a high likelihood standard. And what that means is they're going to look around at how your workplace looks, and they're going to say, well, is it likely that someone would get COVID from working here? And they're going to look for, the kinds of things we've been hearing all through the past year, right? We've been hearing about, if you're close to people, if there's a lot of contact, if people aren't staying 6 feet apart, if the ventilation is poor. So if you're inside and there's poor ventilation, that's going to like count in favor of, yeah, maybe they did get COVID in this work environment. So they're looking for high risk situations where the employer did not take reasonable steps to kind of mitigate that risk. And so a fine will only be assessed in a situation where an employee got COVID as a result of working at your company. As I mentioned, the way that it would happen is that they're actually doing a lot of remote investigations right now, so it could just be a Zoom call. One of the very first things, in fact, based on their own internal guidelines, the very first thing that they're going to look at is they're going to request your COVID safety plan, COVID response policy, whatever you call it. They're going to ask for a written document. Not everyone has that. It's ideal to have it. If you don't, they're going to ask you what you've been doing. They're going to ask you about your procedures, what you've been trying to protect your workers. And then they're going to interview people, look at what you've been doing, and conduct that hazard assessment. If they determine that that the injury or illness was caused or likely caused by exposure at work, they're going to assess a fine, and they're going to produce a report as well, which, as I mentioned, could be used in a lawsuit later. So that's your risk under OSHA specifically. And I will, like I said, I will leave time for questions at the end. I know I'm going to be flying through a lot of material here, but feel free to put stuff in the chat too, and I'll try and circle back to it at the end. So the next big risk is civil lawsuits generally. So this is not an OSHA investigation. This is where your employee actually hires an attorney, files a lawsuit. What types of lawsuits are we looking at here? The first one I want to talk about is a personal injury suit. So everyone's familiar with these, I'm sure, because there are billboards, like all along every highway in Austin with attorneys who represent personal injury plaintiffs. This is your traditional negligence suit. So the argument that they're going to have to make is that you as the employer failed to exercise a reasonable degree of care in protecting your workers. We actually have seen the number of these suits go up over the past year. Unfortunately, it's too early because litigation is so slow. It's too early to really see how these are playing out. As an attorney, I hate that, right? I want to be able to give my clients much more certainty about, where the standards are, what you have to do to make sure that you win a lawsuit. And what's going to happen really is we're going to start seeing these lawsuits play out, see who wins, and that's going to reduce the number of lawsuits, right? Like right now, because we don't know necessarily, because the precedent isn't set, plaintiffs are encouraged to file the lawsuit because it could be that they will win, right? And a lot of these personal injury attorneys work on contingency. So the plaintiff is not necessarily losing anything except for time and probably some emotional stress by filing. So if they do sue you for a personal injury suit, they're going to have to show negligence. And you're going to want to be able to show in response to that suit that you did take reasonable steps. And this is probably sounding very familiar, right? It's very similar to the OSHA investigation in that you just have to show that you made efforts, that you did the types of things that the CDC is recommending, that OSHA is recommending. And this is the reason why right now, if you go into any business in town, you'll see signs that say, wear a mask. You'll see sometimes arrows taped on the ground showing you like how far apart you need to stand. Businesses obviously aren't just doing that out of the goodness of our hearts. Like we kind of are doing that as well because it serves as a way to protect us should we ever get sued. So the other source of lawsuits besides just sort of safety and exposure in the workplace, are what I call kind of the damned if you do lawsuits. So these are risks that arise out of your actual response to COVID. So I, as an employer, say, I'm going to go ahead and make my workplace safe, so I'm going to take these precautions that the CDC and OSHA and EEOC, that these agencies all recommend. But as a result of doing that, I suddenly trigger potential lawsuits under the Americans with Disabilities Act, under the Federal Medical Leave Act. Suddenly I'm venturing into territory where I'm taking on legal risks that I otherwise wouldn't have, precisely because I'm trying to address the safety concerns, right? That's why I call it the damned if you do, because you've got to take these steps, but you have to know that when you take these steps, you're taking on additional risk. So some examples of that, and we'll get into that a bit more if we get to mandatory vaccinations. But some examples of that are, okay, you're taking people's temperature as they come into the building each morning, or as they come into work each day. Now you have what's technically considered health information on them, or somebody reports that they had COVID. Now you have health information. Under all kinds of federal statutes, that information is confidential. So you can't be telling other employees, or anyone really, about the fact that so-and-so has COVID, or so-and-so had a temperature over, 90, 98, whatever the temperature. What temperature are you supposed to be? I'm totally blanking on that. But anyway, so you can't be sharing that with other employees. And if you do, you're violating some statutes that expose you to risk. Discrimination suits. So this is the big one, or one of the big ones. If you, as you should, come up with a policy that says, everyone has to wear masks, or everyone does X, Y, and Z in order to help prevent the spread of COVID, and you enforce that consistently in the workplace, inevitably you're going to come across someone who wants an exception to be made for their case. And some of those exceptions are required and protected by law. So if it's a sincerely held religious belief, you gotta try and make an exception there. If someone is protected by the ADA because they have an underlying health condition that doesn't allow them to wear a mask safely, you gotta try and make an exception there. And all of these little exceptions and nuances can sort of give rise to more risk, right? Because if you make the wrong call and someone is motivated to sue, you might be in a little bit of trouble there. There are other things, like I said, disability, remote work, and leave conflicts. That's if someone asks to be able to work remotely or to take leave for one of these protected reasons and you refuse. That could turn into a dispute. So these are the damned if you do lawsuits. And this is just, I actually pulled this from another law firm, but this is just a national counting of COVID-related lawsuits that have been filed over the past year. And this is not limited to labor and employment disputes. This is kind of everything. But one important thing to note is that if you're a small employer, you're actually at a greater risk of lawsuits. So employers with 50 or fewer employees have been sued at a far greater rate than the larger employers. So that's something to keep in mind. I think a lot of the times, myself included, as a small business owner myself, I sort of feel like, well, I'm more informal, my employees all know each other, we get along. I'm not one of those people who's going to be facing a lawsuit from an upset employee, right? But the reality is, for those reasons that we talked about earlier, even if it's not malicious, just the way the economy is structured, the way that incentives are structured in our legal system, the fact that so many plaintiffs' attorneys will work on contingency means that lawsuits are actually very, very possible. There's something I wanted to add here. Let me see. Oh yeah, I wanted to just give a couple examples of the types of cases we're seeing. I know I'm talking sort of in generalities, but I just wanted to share. So if we're talking about, for example, unlawful termination claims, an example of that would be, there was a case where and it was like very standard, but the employee voiced concerns about lack of social distancing and the fact that other employees were not wearing their masks properly or not wearing their masks at all. This complaint went on the record. He gave it to his supervisor. He was later let go, I think within a couple of months of making that complaint, for what the employer said were unrelated reasons. So he was already kind of, there were performance reviews and everything kind of saying, we're looking at firing this guy from very early on. But the timing of it happened to coincide. And so he ended up filing an unlawful termination claim based on retaliation. So that's the idea that you're being fired for voicing concerns that are legally protected. And as with all of the other lawsuits, this one is still being litigated, so we don't know how it's going to come out. Another example of a recent lawsuit would be someone requesting leave. So let me see here. Oh yeah, this one is really concerning to me. So in this one case, there's a guy who works for an auto repair shop, and he himself is not sick, but he requests leave because COVID has caused a bunch of daycare closures, and his daughter can't go anywhere, and so he has to stay home to take care of his daughter. He requests leave. I think this is definitely sometime last year, and it's denied, and then he's fired. And I don't know the details of why he was fired. I don't know how directly it was related to this, but the guy was basically asking to stay home, and he's an auto repairman, so he kind of needs to be, in a way, he kind of needs to be at work to do his job. But the company let him go, and he filed a lawsuit based on unlawful termination. And this was notably at a time when there was a federal law requiring you to give, as many of you are probably familiar with, 2 weeks of paid leave. That's no longer in effect. So there might be less of a cause of action for that now. But just be aware that, I just want to make sure that's on your radar. The requests for leave aren't always about, having symptoms of COVID or even having a personal fear of COVID. They might be a request based on, the circumstances caused by the pandemic, broadly speaking. Eleanor Roosevelt, you'll be damned if you do and damned if you don't. So all of this bad news, as an attorney, I love being the bearer of bad news constantly. But your best response to all of this, your best defense, really, both from getting sued in the first place and making it a short, cheap-ish lawsuit in the second, is having a really solid COVID response plan, having it written down, and enforcing it consistently. I always tell my clients, you can't actually prevent someone from suing you. If someone really wants to sue you, they can file a crazy lawsuit with no basis, and you're going to have to respond to it, and you're going to have to move forward. But the better prepared you are, the more that you put the facts on your side, the quicker it's going to settle, the less likely someone is to sue you in the first place, because they're going to go to an attorney and say, here's my claim, and the attorney's going to ask all these questions, and when the questions are all clearly coming out with you kind of in the right, that attorney is going to be less likely to take on that case. So it's going to be a lot harder for someone to sue you if you have taken the proper precautions. So specifically with respect to COVID suits, having a response plan in place is and then enforcing it is kind of your best defense. So when I talk about a solid COVID response policy, what do I really mean? I'm pulling this from OSHA's recommendations specifically, and OSHA refers back a lot to the CDC. So these are recommendations from federal agencies. They don't necessarily have the binding force of law. So when OSHA comes out with guidance for how to protect your workers, for instance, as they did in January, I believe it was January, and you can find that online, it's OSHA guide to protecting your workers during COVID, something like that. That guidance is not law. So you're not required to do everything they say in that document. However, the more things that you do that align with those recommendations, the better argument you have that you've taken those reasonable steps, right? That you're not being negligent, that you have taken all the necessary precautions to keep your workers safe. Now, OSHA talks about, they don't use these words specifically, but OSHA's description of a good response plan talks about 4 areas that need to be true of your plan. One, that it's a real plan, that it's not just reactive to individual cases. 2, that it focuses on prevention, so limiting the spread of the disease. 3, it has procedures in place for containing cases of the disease. So where someone actually gets sick, what do you do? And non-retaliation, and we'll talk about a little bit about that later, but that's related to retaliation suits. So I'm going to go into a little bit more depth on each of these, what a good planning process looks like, and how we should go about that. My throat is so dry, I apologize. Okay, so what does it look like to put together a good COVID response plan? First thing you're going to do is you're going to conduct a hazard assessment. So you're going to actually look at all the different things that your employees do, and you're going to kind of rank, you know, like who is most in a line of fire. Someone who's interacting with customers constantly is going to be way more at risk than someone who sits at a desk, you know, privately. You also want to make sure you're soliciting employee input. You're soliciting employee input. This is something OSHA specifically recommends. And the idea here is that employees know better than you where they're being exposed because they're the ones being exposed. One thing that comes up a lot when you start to, or that sometimes comes up when employers start to solicit employee input is situations they didn't really think of. So one commonly missed situation is you're not only responsible for the safety of your workers at your workplace. If you send, for example, salesmen to a customer's site, you're still responsible for their safety there. And so your plan needs to contemplate, you know, coordinating with that other business owner, making sure you know what their protective standards are, providing masks, providing whatever you need to make, and changing procedures even to make your employees feel safer. And that kind of thing is going to come up when you're asking employees, like, how do you feel? Do you feel safe? Like, where do you not feel safe? And how can we address those things? And then 3, make sure that it's written down. Having a written policy is a huge, huge help. Even though it seems like a formality, there are a number of reasons that it can be useful. One, the most pragmatic reason really is for training purposes. If you're trying to train all of your supervisors, all of your managers, and all of your employees to abide by the same kinds of restrictions, having a document that you can point to, that your supervisors can point to when disciplining an employee or giving feedback to an employee, it's really, really helpful. It also makes sure that it's not kind of a moving target, that it's changing all the time. You want to put a lot of thought in on the front end, and then you want to produce a document that everyone is sticking to, because then it's going to be applied consistently. And the more inconsistently you apply the policy, the less effective it's going to be as a defense in, for example, a discrimination suit. So for instance, if you have in your COVID response policy, a particular set of rules or standards for when someone is allowed to work remotely upon request. You know, what kinds of job descriptions work for that, what don't. And someone makes a request to work remotely and you deny it, assuming there are no religious or health issues in play, they can't really, they're going to have a really hard time claiming that you're targeting them with that denial, because you can point to the policy and say, well, yeah, you just don't, like, clearly we have this policy. It's not about you. It's not personal. This is just our company policy that, your particular job function does not meet the threshold for working remotely. So that's the other thing. It's better defense for discrimination suits. It also shifts liability to supervisors or people who are not the company itself if they don't abide by that policy, right? So if you've decided everyone wears a mask and then some employee just refuses to wear the mask or like refuses to wear it properly, and a supervisor is not dealing with that, is not fixing the problem, is not giving feedback to the employee, is just sort of letting it go, and another employee feels unsafe because of that and ends up getting COVID and suing you, the employee is gonna, as part of the evidence that they share, the suing employee is gonna say, like, this supervisor knew that this person was not covering their nose and mouth and did not ever do anything about it. And the company, because they have this policy that says all of our supervisors need to be enforcing this rule, is going to be less liable because basically the company can say, like, your business can say it's not our fault, it's the supervisor's fault, so long as the proper procedures have been followed in terms of disciplining that supervisor, et cetera, et cetera. But the point is, if you're a business trying to respond to one of these lawsuits, having a policy in place is the first huge step towards showing that that you've been trying to do the right thing. And it goes a really long way, honestly, in litigation. Like, having anything written down goes a long way because, yeah, you can depose people and you can take statements, you can do all of that, but there's nothing quite so convincing as like something that was written down before the lawsuit happened, right? I love it when I can get a case where there's actual documentation. It makes the lawyer's job way easier, and it makes the lawsuit less likely to proceed to trial. So the second aspect of a really good COVID response plan is the kind of stuff that we're all very familiar with at this point, and that's prevention. That's limiting the spread, taking specific steps to make sure that the virus does not spread. One thing that I didn't actually include on this slide is employee education. So the very, very first step really is, you can just send an email blast that says, like, this is how COVID spreads, like, take proper precautions. I'm not going to spend too much time on this slide because we're all so familiar with these at this point, but the kinds of things you can use to prevent the spread include the face coverings, face shields, where there's even more exposure. So like at the dentist's office, you'll see this a lot, or like the eye doctor. Social distancing, moving desks so that people are further apart from one another, frequent cleaning, and then changing schedules, using remote work where possible. Basically, you want to take any of these steps that make sense for your business, and that you can do without too much burden or expense. Okay, so this aspect of the plan is where we get into a little bit of more of the legal trickiness, and that's containment. So this is specifically, your plan should address, what do we do when someone is symptomatic? What do we do in terms of people who have been in contact with that person? And then how do we get them back to work, or we know that they're kind of qualified to get back to work? So I want to make sure I have the right numbers here. I think it's, yeah. Okay, so I'm sure all of you have been doing this all year, but this is like sort of a way to check in with yourself and make sure. The CDC and OSHA both are recommending symptom screening. So this means that you don't have to necessarily be testing your employees every day, every work day for COVID, and then isolating the people who have it, right? And the reason for that is probably mainly cost and availability, because if you're requiring a test, you're going to have to pay for it. And also, it's just hard. I mean, logistically, it's impossible to get everyone tested every day for the most part. So what you're doing instead is symptom screening. So you can do this. You can use a self-reporting method where someone has to self-report that they're coughing or that they have a fever. You can also actually, take people's temperatures on the way into work. That's like a very common one, pretty light lift. If somebody does have symptoms, so the cough, the fever, the shortness of breath, you should be isolating them from the rest of your workers immediately. The standard, I think, is, well, I'll get to that in a second, but yeah, isolate them immediately. Then you want to use contact tracing and or testing to try and make sure that it doesn't spread from that particular case. So anybody who's been in contact with that person who has the symptoms should ideally be quarantined for 14 days following that exposure before they're let back to work. Now, for a variety of reasons, a 14-day quarantine for every single person who has been in contact with that symptomatic person may or may not be feasible. There are ways to work around that. What you could do is require the person who had the symptoms to actually get tested, and then only if they test positive do you require that 14-day isolation for the other workers. You could, instead of requiring all the workers who have been in contact with the symptomatic person, instead of requiring them to be quarantined for 14 days, you could have them go get tested, right? Because then you can see who needs to be quarantined and who doesn't. But you need to have something in place where you are trying to limit the spread once you've spotted an actual case. Where appropriate, that should involve paid leave. Now, this has actually changed a lot over time, and it's still kind of a moving target because the federal government keeps putting out new legislation or changing rules. But at least last year, under the FFCRA, Families First Corona Response Act, you as an employer had to give, I think if you were under 500 employees, you had to give 2 weeks of paid sick leave for quarantine, for COVID related leave. And then you can get that back in refundable tax credits, 100% of the paycheck up to a certain point. That actually expired at the end of last year. And although the refundable tax credits are still in effect, actually now, I'm actually going to move forward a couple of slides since I'm talking about this anyway. We're under the American Rescue Plan Act of 2021. So that actually kicks in, I believe April 1st is when that kicks in. So if you provided leave to an employee under the previous act, this ARPA actually resets the clock. So say you've already given 2 weeks of leave to someone, and then you have to give them leave again because of a quarantine issue, because they have symptoms. This new plan will give you another 10 days of refundable tax credits. So you can give them up to 10 days of paid leave for COVID-19 reasons. ARPA has also extended the reasons that you can give this leave. So not just if you have symptoms or have been exposed, but also if you're taking time off to get vaccinated, if you're experiencing side effects with vaccination, like some people get the flu symptoms, or if you're awaiting the results of a test that wasn't requested by the employer, all of those qualify for this, for these refundable tax credits. So if you're trying to, get people out of the workplace, isolate the virus, you can take advantage of this program. Unlike the previous law, this is not mandatory. So if you decide, okay, I need to isolate someone from the workplace, but I'm not going to pay them for that. I'm just going to make it unpaid leave. That's technically okay. Just know that, you're more likely to make someone mad, right? You're perfectly within your rights to do it in Texas. Depending on the nature of the employment, but if you can do paid leave, it's the less risky proposition, obviously, because then you're less likely to get an angry employee. I also just wanted to mention, I'm going to go back a slide real quick. But in terms of return to work, these are the CDC's recommendations. You want to wait if someone has been sent home for symptoms. You don't want to let them back until 10 full days from the onset of their symptoms. You want to make sure they've had 24 hours with no fever and that their other symptoms are improving. And you want to get the employee to affirmatively state that this is all the case, because you want to be able, again, being the doom and gloom lawyer, if someone comes back and then is still sick and infects someone else, you want to be able to say, like, I got assurances from the employee that all of these things were true. I took their temperature, I did all of the things necessary to try and prevent this from happening. And so it shouldn't be considered my fault that this disease has still spread. And that's kind of the thing about all of this, right? Like we as business owners we're not fully in control of everything that can happen within the workplace, right? And the law doesn't expect us to like fully prevent any spread of COVID, but it does expect us to take reasonable efforts, going back to that phrase. Okay, the final aspect of a solid COVID response plan, according to OSHA, is non-retaliation. And so, I talked about this a little bit earlier on. If you terminate someone and they claim it's because they were, expressing concerns about the safety of the workplace, they could have a retaliation claim under OSHA. And one way to protect yourself from that kind of claim is to make sure that you have a process in place for employee feedback and complaints related to COVID and your workplace safety plan that is ideally anonymous, although the smaller you are, the harder that is to do, right? But also outside the normal chain of like performance review. So for instance, if I as an employee am told that if I have concerns about the workplace safety plan, if I have concerns about getting COVID at work, I should talk to my supervisor, and then later I'm fired, that creates a problem because the supervisor is the one who does my performance management, right? They do my performance reviews, and they were the ones who heard that I had these concerns. And so even if one had nothing to do with the other, it's a lot easier for a plaintiff to make the connection that that was the reason that the supervisor, recommended my termination or did terminate, however your performance management system works. So ideally what you have is a neutral point of contact. So someone who doesn't usually supervise me, who has nothing to do with my performance management, but is maybe empowered to be like the COVID response coordinator in my workplace, they should be the one that I go to with my complaints. And they should actually keep those complaints anonymous when they report them to management. So that way there's so much less exposure to risk for you as an employer, because if I as an employee later sue saying, well, you retaliated against me, you can quite honestly say like, well, the people who made the decision to fire you had no idea that you even made those complaints, right? So that's a really powerful, simple tool, kind of, it's a little bit low-hanging fruit to make sure that you're protected in that case. I think I'm going to skip this slide for now, but those are like some small pitfalls to avoid when putting together your plan. I think I mentioned the confidentiality and the fact that, you do have to make exceptions. Even though you're enforcing this plan consistently, make exceptions for protected categories. And now, let me see. Looks like I'm going to take about 5 minutes if I can, and talk about the vaccine a little bit. Let me actually see. Do we have any questions in the chat or anything like that we should?
There are none in the chat right now, but I have some from a couple of people who have messaged me.
Okay.
You've got 5 minutes. You're fine.
Okay. All right. Cool. So I'll do the 5 minutes on the vaccine, and then we'll tackle questions. So the reason I want to address the vaccine is obviously this is like more recent, and there's honestly not huge consensus on whether or not employers should make it mandatory. So just a couple of things about the vaccinations that are available right now. They're authorized under the FDA's emergency use authorization, not their usual intensive process. Obviously it's, they're trying to get it out there as quickly as possible. And so you could make the argument that, it's less certain that it's a safe vaccine. Apologies for the typo. The first lawsuit has been filed already related to a mandatory vaccine policy. It was just filed, like I want to say a week and a half ago, 2 weeks ago. So everyone's sort of watching that. It's a New Mexico case, but I mean, litigation is slow. Like if any of you have been in litigation, it is a slow process. So we really don't know how that's going to come out. It's also against a public employer, which is going to be different than a private employer. And one of the sticking points in that lawsuit specifically, and sort of lawyers kind of foresee this being the issue in a lot of lawsuits that are going to come out of this, is that the emergency use authorization vaccine standards specifically say that when someone is being administered a vaccine that's been authorized that way, they need to be informed that they have the option to accept or refuse administration. And that's that part in quotes down there, which, you know, obviously, if you're being told by your employer to get it, you don't really feel that you have the option to refuse it. And so the question is, by requiring a vaccine that's authorized under the EUA, are you basically violating the federal provision that even authorized the vaccine in the first place? Now, that same language also includes the consequences of refusing. So you could argue it both ways, and all the lawyers will, I'm sure. But yeah, it's going to be interesting to see kind of where that lands. What we do have at this point, though we don't have settled case law, is we do have guidance from the Equal Employment Opportunity Commission, which administers a lot of these, like Title VII, all of like the discrimination laws and things like that. And the EEOC has actually said that employers may require vaccinations as a condition of employment. So most attorneys at this point will say, like, yes, you technically have the legal right to require your employees to get vaccinated. And the reason that you can require that is because under the ADA, you have the ability to set what's called a qualification standard, which means that you can say, like, in order to keep my workplace safe, I'm requiring certain things of my employees. And the vaccination can fall under that. So the short story is that you can require vaccinations, but you take on two big risks, and it's kind of what we were talking about earlier, like making exceptions for people who have valid requests protected by ADA or Title VII. I'll get into that a little bit. So an ADA protected disability in this context would be an underlying health condition that makes it more risky for you to get the vaccine. So something like pregnancy would work, heart conditions, anything that, you know, health authorities are saying makes you more at risk could be considered an ADA protected disability. Under Title VII, which prohibits discrimination against employees on religious grounds, if you have a sincerely held religious belief that prohibits you from receiving the vaccine, that also requires reasonable accommodation. I wanted to talk just really briefly about what that looks like. This is a huge area of law. But essentially, you as the employer, generally speaking, you should, if someone raises one of these objections, if they say, like, I can't get the vaccine because I have this health issue, or I can't get the vaccine because my religion won't let me, you should start by taking that at face value. Like, your default should be to believe the employee. However, if you have sort of an objective reason for believing that that's not true, that they're kind of maybe fudging something or lying, you can request additional documentation. So especially under the ADA, you can request, you know, information from their medical provider. For sincerely held religious belief, it's a little stickier, right? Like, what do you request? Companies before have requested letters from clergymen and things like that, but that gets really difficult because when it comes to a sincerely held religious belief, like, the law is very clear that it doesn't, for me to have a religious objection, does not require that the objection be something that's like an official tenet of the religion, right? So like some easy ones are, you know, Jehovah's Witnesses. It's a tenet of their religion that they cannot receive blood transfusions because of their beliefs that it contradicts certain aspects of the law, of the Old Testament law. that's like a pretty straightforward religious exception. But if I'm a Methodist who doesn't want to receive the vaccine, but my Methodist preacher says vaccines are fine, my pastor and the Methodist Church says vaccines are fine, that doesn't necessarily mean that I don't have that I'm not entitled to reasonable accommodation. So it's not about what the religion officially holds. It's about whether your belief is a sincerely held religious belief. And then courts have also stated that philosophical beliefs are not quite religious beliefs. So your religious belief, to be a religion, it doesn't have to be theistic, but it has to concern, I think they've used the word like ultimate realities, like life, death, and eternity. So simply having a strong moral conviction that you should keep your body safe and therefore you shouldn't receive vaccines does not rise to the level of religious protection. In either case, whether it's a health-related objection or a sincerely held religious objection, there should be a back and forth with the employee. Lawyers call this the interactive process. So essentially, you want to gather as much information as you can from them, and you want to brainstorm alternatives to the measure that they're objecting to. And you kind of want to land on something that, if you basically you want to be able to still reduce or mitigate the risk of spreading COVID while not sort of violating their rights under these laws. So it's very tricky. It's very fact specific. There's not like a blanket rule. It's a process you're supposed to go through with your employee. And you as the employer can ultimately deny the accommodation or give a different accommodation than the one requested. If the one that they requested would cause what's called undue hardship. So basically, if it would just take way too much time and money to try and make this feasible for them, given their beliefs or their health issue. But it's just really tricky, very fact specific. I would recommend getting a lawyer involved at that point if you're looking to deny one of these accommodations. And I think that's actually all I've got. So if we want to jump to questions, I'm happy to do so.
Yeah, so let's go ahead and do that. We had a couple of questions come in. You had mentioned OSHA's threshold and civil lawsuits, but who decides what's reasonable precautions? For example, with Texas, there's no longer a mask mandate, but the CDC still recommends it. How are businesses to decide what to do?
That's a really good question. So the fact that Texas has gotten rid of the mask order has actually made things a lot harder for businesses. Because it's no longer quite as clear cut as it once was. And you might, like, for example, if you're in Austin, you might still be subject to an Austin-based mask order that's, being disputed in court, though you're no longer subject to a statewide one. So it is like a really, really confusing environment to be in. Ultimately, the answer to that question is very unsatisfying. So the answer to that question is that the person that decides what's reasonable is the judge or the jury. And all you can really do is do the very best you can to avoid getting there in the first place. And as a lawyer, most lawyers at least, are always going to recommend the most conservative approach, right? So I'm still recommending to my clients that you require masks, because I can't really see an argument not to. The only, at least not a legal risk related argument. The real argument not to is customer pressure and business pressure, right? So that's the reason not to require masks. But in the current environment, specifically because OSHA's guidance is still recommending masks. OSHA still says that that's like one of the best, most basic ways to be protecting your workers. And the CDC is still recommending it. I can't really see a good argument for not requiring it at this point.
Okay, that kind of leads us into a question from somebody who wasn't able to attend but wanted me to ask this question. If I require a screening before allowing somebody into my business, but that individual refuses that screening, what is my best course of action?
Oh yeah, that's a tricky one. So it depends on the nature of the screening. So if you're doing something like temperature taking, you're within your rights as a private business, assuming you're a private business, not like a city hall or something. You're within your rights to set policies to protect your customers and employees within your own walls. So, and you can set the terms of, you know, who's allowed to come into your, as long as it's not discriminatory, right? Like you're allowed to set the terms of who comes into your business and who doesn't. So if you've set a requirement that, you know, everyone has to get their temperature taken, you can turn people away. And technically, if they refuse to leave, they're trespassing. So in the same way that you can call the police, now they always want to call the police, but in the same way that you can call the police if someone's trespassing, you can call the police if someone is trying to stay in your establishment without following the rules of that establishment.
And for my own follow-up on that same question, would it be best to have that posted outside before they try to walk in?
Yeah, I mean that's a great option. Just so you know, people. I sort of am, my own, I guess, prejudice is that if someone is going to be like difficult enough to refuse to, you know, get their temperature taken, they might be difficult enough to push the issue even if you post it on the door, you know. Like I don't know how many people you're gonna avoid confrontation with that way, but yeah, it certainly can't hurt to put that on the door.
Very good. That was all the questions that we got. You covered quite a bit, so thank you, Maggie. And we will make sure, there you go, that you know, you can find out how to get in touch with Maggie. So once again, we want to thank you. Thank you to our sponsor, Cedar Park Economic Development. Thank you all for spending some time with us this morning. And be sure to look for us for our next Chamber University. Everybody have a great day. Thank you.
Thanks so much.